Franchise litigation is a last resort in this law firm in terms of seeking a remedy or relief when a dispute arises between the franchisor and the franchisee. We always seek to resolve disputes using alternative methods pre-litigation, but there are times when the business person's face-to-face meeting or the settlement conference or the mediation just simply are to no avail and do not achieve the remedy desired. That litigation becomes the end result. And the litigation issues follow all scopes of legal claims. You can have, a declaratory action, which is simply that the parties, the franchisor and franchisee, don't agree on the interpretation of a particular contractual provision or the interpretation of what a franchisee must do or must not do versus the franchisor thinking they should do it or should not do it. And the court declares as to who's right and who's wrong. Then you have breach of contract provisions where one party fails to perform their obligations under the contract. Then you have a breach of the implied covenant of good faith and fair dealing, where the law says that no party to a contract can act in a manner that interferes with the other party's ability to gain the benefits and fruits of that contract. But typically, that is a legal doctrine that is implied in almost every state in the country, but is typically tied to an express provision of the contract that the franchisor is not performing in good faith. Then you also have fraud claims. You have negligence claims. You have all sorts of statutory violations. You have deceptive and unfair trade practices acts. You have violations of state pre-sale disclosure statutes. And you have claims arising in certain states as to the franchise relationship and the violation of those franchise relationship statutes that exist in those states. There's a whole gamut of claims that arise depending on what the issue is at hand.